So, dear ladies and gentlemen, distinguished experts and guests, thank you all for being here with us today, be it in person here at the headquarters of Konrad Adenauer Foundation, KAS in Berlin, or online through our live stream. It's a pleasure for me to welcome you on behalf of the Konrad Adenauer Foundation. Data is the new gold. This is how Philipp Bremer's preface to the study begins. In recent years, it has been shown that the great potential of the use of data for innovation, for business development, and for more individual comfort. But as in other areas, legal frameworks are important in order to secure our personal freedom. Surely a milestone in European legislation was the General Data Protection Regulation, GDPR. Very complicated name, but very important. The GDPR has been in force since May 2018, and for the first time it regulates how companies are allowed to handle personal data in a uniform manner throughout the European Union member states. It focuses on the individual's property of his or her data, whereas in other regions of the world, the focus lays more on the business sector or the government sector as the owner of the data. In my view, data protection is key to individual freedom, a prerequisite for a functioning rule of law, and it can lead to great damage to the economy and society if it fails. Security aspects must also be taken into account in data protection legislation in order to protect the freedoms of others. Comparative overviews of data protection laws, as done in this study, can promote and strengthen the protection of personal data. I want to thank my colleague Philipp Bremer and his team of the Rule of Law program in Beirut, responsible for the area of Northern Africa and the Middle East, and as well the authors of the study presented today, Professor Hennemann and Dr. Boshe from the University of Passau, for carrying out this important project and for raising awareness for this relevant topic in your region in Northern Africa. I appreciate very much your bringing your insights, experiences, and facts about the development of individual freedom and the rule of law in North Africa, our neighbor region, to Berlin. To be frank, the GDPR, at least here in Berlin, has been criticized a lot for the bureaucratic obligations which its concrete application by the German authorities has produced, and for business companies and in part also for the individual user. So I look forward to hearing from you today how the challenge is being handled in your region, which we have been addressing since 2018. This event is intended to provide a platform for an exchange between the relevant actors from different areas, academia, state, and legal practice. For our audience abroad and across North Africa, this event is recorded and streamed online, and it will be held in English language as announced. Printed versions of the study are available here today. I must show you one. It's very nice. And it's also available, of course, for everyone on the website of the Rule of Law program of Konrad Adenauer Foundation. Now I want to thank you all for your presence and your interest in this decisive issue for the present and even more for our future. With that, I hand over to my colleague Philipp Bremer, wishing us a very fruitful afternoon with this topic. Thank you very much.
Thank you, lieber Dr. Fischer-Bohlin, lieber Dr. Rinke, distinguished panelists, experts, and guests, ladies and gentlemen. Working in the Arab region, I'm used to saying ahlan wa sahlan, mas al-khair. This afternoon, I can keep it to welcome. Herzlich willkommen here or in front of your screens at home. It's good to be with you here in Berlin and to be able to welcome you all to the Academy of the Konrad Adenauer Stiftung. It's special to be able to present our study on data protection laws in Northern Africa here in Berlin, at our headquarters, at home, if you will. And it's a pleasure to be able to discuss this timely and important topic with you and to try and build a bridge between Europe on the one side and Northern Africa on the other. Much like I did when we presented this study in Tunis recently, allow me to start with a somewhat weird or strange question. On your social media, so Facebook, Instagram, TikTok, have you recently seen advertisements for cat food? Because now I never do, although I know there's a lot of it. But I never see it. I suppose I'm not the correct target group. But recently I was, briefly, flooded by it. The moment I deleted all the cookies and the history on my PC that it had collected from me and thus didn't know who I was anymore. We started fresh. No collected cookies, no history, no data. And then, cat food, I guess. Seems a good enough place to start as any. Personal advertising is just one example of how data can easily aid companies and businesses. But as we've witnessed more and more in recent years, personal data can be used for so much more. Entire election campaigns have been built on targeting populations through specific advertising based on personal data and profiles. So not only by businesses, but individuals and states. With all the digital abilities that we have today, data, and you mentioned this, is indeed the new gold. And much like gold, once discovered, there's a rush to collect it and use it for marketing, for trade, national security, defense, surveillance, and other manifold reasons by both the public and the private sector. Data is extremely useful and helpful. However, data collection, processing, and storage also pose a serious threat to basic human rights and freedoms. Data subjects are under an ever-growing risk of having their data misused, accounts hacked, and personal information unwillingly being turned against themselves. And this is a global phenomenon. So the question stands, how can legislation protect the personal data of individuals in times of mass social media, big data, legal tech, and artificial intelligence? Because it needs to. And how can legislation remain flexible and up to speed during the ever so quick developments of data technology? Data protection regulations are growing worldwide in number and complexity. And such regulations really aren't an easy task, as we will hear today. As we will discuss in North Africa, the legal frameworks for data protection are in recent years slowly but surely being updated and put in place. Algeria, Egypt, Mauritania, Morocco, and Tunisia have all passed comprehensive data protection laws. Looking at these laws, the GDPR seems to have been a template. It should be clear to us, as Europe, we are exporting a model. But how helpful is this? How fitting is this for North African countries that all must be looked at individually? How are these laws being laid down? If data is the new gold, we should be aware of how to deal with the rush. Make sure we have a balance between economic prosperity and protecting human rights. And we also need to support and accompany the global implementation. Final words, as the Rule of Law Program, Middle East and North Africa, we want to focus more on this topic. It was important to us to have this comparative study carried out to be able to tackle the regional legal aspects of data protection in the book, but also at a later stage to look at the implementation of the laws. I would really like to thank our authors once again, Professor Dr. Moritz Hennemann and Dr. Patricia Boshe, for all their thorough and tireless efforts in researching and writing this study. We're proud to be able to present it with you here in Berlin today. Thank you for this. I'm also honored and very appreciative of our panelists that are with us today, all experts in the field. Thank you so much for your time and for sharing your expertise with us. Thank you to Mark Haldani, experienced data protection expert and advisor to the GLACI project of the EU and the Council of Europe, Dr. Tobias Born, senior associate and data specialist at Baker McKenzie in Frankfurt, and thank you, Philipp Schurte from GIZ, a policy advisor there for digital development, for moderating this panel today. Thank you all. I'd like to thank Headquarters, Dr. Fischer-Bohlin, for your support. Thank our Rule of Law Coordinator, Dr. Franziska Rinke, and her team. Thank Vivian, also, please, for all her hard work, for the readiness to prepare this event. And I'd also like to thank my team, Valeska in the back especially, for all her great support and organization. Finally, thank you all for coming. I'd like to wish us all fruitful forthcoming deliberations. I hope it's an insightful and informative presentation and discussion that I really look forward to. And now I'm really happy to hand over to Dr. Patricia Boshe to present the study to us. Thank you so much. Herzlichen Dank.
Good afternoon to you all. Thank you, Philip. And as Philip already introduced, that today we are going to talk about the findings of a research that we conducted last year with Professor Hennemann on data protection in Northern Africa. We did look into 7 countries, but because within those 7 countries that Philip already mentioned, Tunisia, Morocco, Egypt, Sudan, Mauritania, and Algeria, we only found 5 countries that have data protection up to this moment. And so we did a research of those 5 countries, that is Morocco, Tunisia, Algeria, Egypt, and Mauritania. And so the study, basically, we wanted, as Philip said, we want to look at the law in the books. What are these laws reflect? Is there any influence from other regulations? Because as Alex said before, there are those laws that focus on an individual, but other laws focus on economy, on other aspects, countries like USA. But is there any effect from other regulation in Africa? So what we saw in North Africa is that, first of all, the 5 countries imitate or sort of represent the blueprint of the GDPR in terms of content and context. We can see overall, for example, also in the African region, the African countries that have data protection up to this moment, most of them sort of reflect the effect of the European legal framework for data protection. They focus on the protection of an individual rather than companies or trade or commerce. The same we've seen in North Africa. The four countries, that is Mauritania, Morocco, Algeria, and Tunisia, were developed before the GDPR. They present a sort of blueprint of the old framework, that is the Directive 1995. And Egypt, which is after the GDPR, present a similar framework which also represent the old directive. When you look at these 5 countries, you can see, as I said, Morocco, Algeria, Tunisia, and Egypt, they all present, or they all lay down a foundation for a similar framework like the GDPR. But the alignment is seen not only in substantive law, but enforcement mechanism. The laws propose for establishment of commission, that is an agency that enforces these laws, a standing independent commission that can enforce these laws, and the substantive rules that reflect what is provided under the GDPR. But there are some things that are not provided or cannot seen in the GDPR, but you can see in these laws. But that is not to say that they really differ in terms of form and content. But these brought us to a question as to whether these laws needed, or these countries needed, something more than the GDPR to represent the context of these countries. For example, you will see in, for example, Tunisia and Algeria, there's an extra protection for children. In GDPR, you see that a parent is allowed to give consent for the processing of personal data of a child. The same in Tunisia and Algeria, but there's an extra layer. A judge or family court is allowed to give such consent in case a parent refuses to give a consent for processing of personal data of a child when the interest of a child is involved. That is not provided in the GDPR. Again, in Tunisia and Algeria, data of a deceased person is protected. So people who the family of the deceased person are allowed to come forward and enforce data right of a deceased person. That is not something that is seen in the GDPR, although the GDPR allows countries, European countries, to have such provisions. And then we have, in all 5 countries, we see there's a requirement, it's an obligation, a requirement to register or give licenses to data protection commission. That is not the same with the GDPR, within the GDPR framework. Again, we see the requirement of notification. Data protection in the 5 countries requires that before data is processed, the data controllers must notify the data commissioners that they intend to process certain kind of data. This requirement is not seen in the GDPR. The same with authorization. The 5 countries requires that the data controllers require authorization before they process personal data. Again, this is not seen in the GDPR. And also, something that is really interesting within the 5 countries is that in the substantive rules, we have 7 data protection principles. Among the 7 data protection principles in all 5 countries, transparency is omitted. So this can be seen like representing or speaking of political context of these countries and the things that data protection law might represent within African context, despite the fact that these countries have sort of been inspired by the GDPR. And lastly, and also quite interesting, is that although these countries, the 5 countries that have similar framework like the GDPR, those countries to this date have never or have not been issued with adequacy decision by the EU, regardless of the similarities of these laws. That also speaks of geopolitics issues within African, or may not be African, but other countries in relation to transposing other frameworks for data protection. As we said before, the research was focused on the law on the books to see what is there, what are sort of similarities, why or what were inspiring motives behind adoption of these laws, which reflect the GDPR in African continent. The idea is to see whether there are similarities, whether there are divergences, and why are there these divergences between these countries. And this foundation will also help us to understand whether or not these differences affect the practical enforcement of these laws within African countries, specifically focusing on the case studies we studied in the Northern Africa. With that, I would like to thank you all and welcome the floor for the discussion. But before that, I'll hand over the mic to Philip again so that he can welcome the the panel discussion. Thank you.
Thank you, Patricia, for introducing us to the study. My name is Philip Schulte. As I was already introduced, I'm policy advisor at the GIZ headquarters based in Bonn. I advise the Federal Ministry for Economic Cooperation and Development on digital development. And I'm delighted to moderate the panel today, since I think we have an excellent panel here with experts from the field of the new gold, from data. with us today is Tamara Kaldani. Tamara, you were the first data protection commissioner in Georgia. You established an independent supervisory authority from 2013 to 2019. And since then, you have been serving as an expert to the EU, to the Council of Europe, World Bank, UN agencies, and of course GIZ. And there you have contributed to the development of data protection legal frameworks, mainly in Africa, in countries such as Kenya and Ghana. Next on the panel, I introduce you to Tobias Born. Tobias, you are a senior associate with the law firm Baker McKinsey, based in Frankfurt. Prior to that, you have you served as an head of data protection at eBay, and you were responsible for the Europe, but also for the Middle East and Africa region. And you're an expert on IT and data protection law, and you advise domestic and international companies on various aspects of information technology law. And you hold also a PhD on data protection authorities. Welcome. Last but not least, I introduce you to Moritz Hennemann, one of the co-authors of the study. Moritz, you are a full professor and director of the Research Center for Law and Digitalization at the University of Passau since 2020. You studied in Heidelberg, Krakow, Freiburg, and Oxford, and have been a postdoc fellow at Freiburg and also visiting researcher at Harvard University Law School. Welcome. So, to give us more an idea why data protection laws is important to us, Tobias, I want to start with you. As a lawyer, you have to work with data protection laws, on a daily basis. So a very practical question for you. How do you get an overview of regional and national regulations? What are general challenges and problems, and will this study help you?
Actually, the study will help me because in our firm, we even have some kind of a privacy handbook where we try to summarize essential requirements under local data protection laws, so very similar to what you did. And I took a quick look, and actually none of the countries that you covered are covered in our privacy handbook. So it's great work, which really can help on a day-to-day basis, even though we, as German lawyers, do not advise on local laws. But depending on the case, it can be helpful to take a first look so that you already have some kind of indication before you reach out to local colleagues, either internally in our law firm or externally from other law firms, because then you already know what kind of topics could be relevant, even though we've already heard from Patricia that in many cases the legal framework is actually similar because it has the same basis, either the GDPR or the predecessor, is it my microphone? The Data Protection Directive. Nevertheless, getting this overview is helpful.
Yeah, thank you. Tamara, you work on another side of the data law, I would say. So you helped drafting African countries in data protection laws. Can you give us some insights? What did you do there? What was your job? We talked before, you have many hats on. Can you give us an explanation? What was your task?
Sure, absolutely. Thanks, first of all, for inviting and having me here. Indeed, I had a privilege to contribute to drafting or reviewing data protection bills in various countries from different regions, including in Africa. I contributed to the development of the draft bill of the Gambia, reviewed Kenyan one. In 2021, we had an opportunity to work with Sudanese counterparts and build the zero, let's say, draft, but unfortunately political instability and escalating violence prevented us to hold public consultations and continue drafting, but also on behalf of European Union and GIZ Commission projects, I work very closely with newly established data protection authorities in Africa, mostly in West and East side. As you mentioned, I'm former commissioner myself, and the one who is built the office from scratch. So I've been in their shoes. I know the challenges that they're facing and helping in strategic planning, building capacity of complaint handling, investigation, and enforcement is mostly very rewarding for me. Generally, I have contributed to, with different roles, to development of or reviewing of more than 15, let's say, drafts or laws. In Africa, I worked so far in 6 countries.
6 countries. Yeah. Moritz, a third angle on data protection laws. At your research institute, I learned that you one of your projects is mapping global data laws, and I assume this study is part of, or at least issued run of this project. What was your idea behind this research project? I mean, we got the GDPR in the introduction. We learned that there's a lot of issues with GDPR, at least in Germany and Europe. Isn't there enough to do?
There is enough to do with regard, obviously, to the GDPR and all the nitty-gritty details, but that was not our focus. It is the focus of the legal practice, but obviously also of academics. But our wish, or you could say we were just curious to learn how data law developed worldwide, or is developing worldwide, how data protection laws have spread. And to that end, we, as others did before, we started from the idea that we need a basis to have access to all the different data protection laws, to the data protection law drafts, around up to 160 to 170 countries worldwide nowadays, and all those are accessible via our website and via our maps to get a first insight into the specific law. But that's only the starting point. The second and more challenging question obviously is, why do we see this process? Why has the Data Protection Directive and later the GDPR been so successful, such a successful model that is not the model everywhere in the world? China has a little bit of a different one. The US definitely has a different approach. Other countries do as well, for example, Switzerland to some extent. But generally speaking, the GDPR and the directive both have been very influential all over the world. And one answer would be that it's a brilliant law. It's a brilliant model that others like to follow. Another argument could be harmonization, as we have heard that global trade, global interaction, global data sharing, global e-commerce is relying on data. To have similar rules at different places does add some economies of scales for businesses. It could also be that the EU is very powerful in pushing its standards. That's what normally phrased as the Brussels effect, that the EU is setting high standards where others who like to target the EU market have to stick to those rules, and for different reasons stick to those rules then also in other areas of the world, and other lawmakers to orientate themselves at the GDPR. But as a third step, obviously, we also engage with the criticism about this process, as obviously exporting a specific law is not free of doubt, as it goes along with values, a specific concept, specific constitutional values which are underlying these law, and it's one of the first things probably you learn when doing comparative law, that it's quite hard actually to transplant a specific law to another region, especially if it does not consider regional values, regional settings, the regional context. That could also be the regional economy and all these different aspects of concern for us.
I might continue with that. Tamara, are you transplanting European legislation to African countries?
Obviously, key principles. First, let's start that privacy and right to data protection is fundamental rights, and many constitutions, all constitutions of the states we mentioned, and many others, obviously provide some safeguards and guarantees, and there are key principles which should be applicable no matter where our data is processed. So this is a very important aspect, but even Patricia during her presentation highlighted the differences, and we always take into account the national context. Everything needs to be contextualized, and therefore even in many African states you will see that among sensitive data there are certain data which is not sensitive according to the GDPR. Even the registration obligations and licensing obligations, they're coming from the need to identify the data controllers, because there are challenges to identify and then hold them accountable. Even the protecting best interests of child. It comes from the vulnerability of children, and therefore states try to secure, let's say, their processing. So obviously we take into account those basic principles which are not only enshrined in the GDPR, but we see in other frameworks like Convention 108, we see it in many other regional and international, let's say, instruments. But at the same time you will see many differences and also similarities between African, let's say, in African contexts. But obviously we do not copy-paste, and usually these consultations we are not drafting on behalf of the state. We're engaged and we consult, first of all, national drafting teams, and we provide, let's say, our expertise, but these are national stakeholders, lawmakers who should make decision about the law. We're here to share, let's say, our experiences, lessons learned, and best practices.
Thank you. From a more practical perspective, transplanting any legislation or European legislation to other countries, is that something your clients would want? Is that something which would ease your job, or?
I would say that it's something that clients want, because it makes life easier for them. Many of our clients, and also many big companies, they have global reach, so they don't just act in Germany or just the US, they act maybe in all continents. So the more similar the laws are, the easier it is to implement compliance measures, because then you can have a similar approach across the world. Because if you need to implement different measures in different regions, it means extra work, extra efforts, increases the risk of mistakes. And it makes it very difficult from a practical perspective to implement a coherent framework across the company, which also leads to extra costs, maybe also additional vulnerability of systems. So there are different factors that play a role here. So having a data protection framework that at least has a similar basis in different countries is really helpful. And I think this is also one of the reasons why many countries, not only in Northern Africa, but also other regions of the world, at least try to implement something that is similar to GDPR, even though we've already heard that from Patricia, and we also know that from other countries, in some regards, implement or enact provisions that deviate from the European standard to comply with local culture or other local requirements. But nevertheless, it makes a lot of sense, because we also heard that like certain requirements in terms of information, legal basis. It's very, very similar. So once you look at the data protection law in other countries, you very soon feel very familiar with it, because you see this is similar, this is different. And even if you do not directly advise on the law, you can maybe already tell the client, okay, we know, let's say in this country, we know there are registration requirements. Of course, we need advice from local counsel, but we can already tell you that. But that's basically the only thing. In all other regards, the law is similar. And this helps a lot in practice. And just think of things like privacy notices. If you need to implement a privacy notice based on local laws that is different in, let's say, 50 countries, and many companies operate in 50 countries, and even if it's just for their employees, because also they need to be provided with relevant privacy information, if everything needs to be done on a local basis differently, it's a lot of work. Keeping it up to date is extremely difficult. And this is also one of the reasons why GDPR was such a great thing, because companies were hoping to have a uniform legal framework, at least in one important region, the EU, right? We know that there's a lot of difficulties in this regard, because the GDPR has so-called opening clauses, which allow local legislation in the individual member states. And also, it has been touched briefly with regard to Northern Africa, that there are data protection authorities, at least in some countries. In Europe, we have data protection authorities everywhere, but they apply the law also differently in practice. So this is another point which makes it even more difficult. But at least having the same law, this is the very, very important basis here. And therefore, I totally understand if other countries copy and paste, at least to some extent, the European approach. And I mean, there's also a lot of history behind that. GDPR is something, we heard that, which became applicable in 2018. It's the successor of the Data Protection Directive from 1995, so almost 30 years ago. And the Data Protection Directive is heavily based on previous German laws. So the first data protection law, modern data protection law in the world, was made in Germany, in the German state Hessen. So there's quite a lot of history and experience behind that, and I think this is also one of the reasons why countries decide to implement the same standard, because they know there's a lot of experience with that, and maybe also Europe as one of the most important trading partners for the African continent. There's a closer relationship maybe than to other regions like the Americas.
Yeah, just to follow up, turning to Africa, how important is Africa for you in a legal practice?
To be honest, the relevance is relatively low. I also double-checked some projects I worked on. So I do a lot of projects with international data transfers. So for example, intra-group data protection agreements, because many companies, they need to exchange data. And many data protection laws, including GDPR, require you to have certain data protection agreements in place. And specifically, if you transfer data to third countries, so from an EU perspective, it's all countries outside of the EU. And I hardly have ever worked on any cases where African countries were in scope. So we have had quite some projects with Southern Africa, and I found one project where Egypt was in scope. But I also asked a colleague from Munich, and other African countries are hardly of any relevance, at least for our clients, which may have different reasons, either because they don't have establishments on a local level in these countries, or also just for practical reasons, because they need to prioritize. If you want to roll out, a digital product on all 5 continents, then you normally start with Europe and or the US, because these are the countries that have the most comprehensive and most complex data protection laws, which are also enforced. And then you go to other regions. So this is a very typical approach, that you roll out projects or products in waves, starting with certain countries, normally the ones with the highest data protection standards, even within the EU. So you often start with Germany, maybe Italy, Spain, the UK, even though it's not EU anymore, then go to the US, Asia, Australia, and then Africa. And I think in many cases, Africa just like falls off the boat, sort of, because it's just not as relevant. And we have heard that from Patricia, if there's no data protection authority, if you don't have to fear anything, why should you do anything from a practical perspective?
if I may add, because business perspective was very well demonstrated and covered, but I want also to pay attention to the, let's say, incentives and perspective from public authorities, because data sharing and the convergence between legal systems is not only important for businesses, but for public authorities, because many public authorities, when they deal with international crime or national security threats or common challenges, cybersecurity, they also need to share data. And sometimes the difference between legal regimes and the security of data is the main challenge. So during consultations, I had a chance to talk and discuss with public authorities, especially criminal justice or national security authorities at the national level, who see also the great value in developing nationally data protection legal frameworks which are convergent and more or less similar to internationally or at the European level, let's say, acknowledged standards. And indeed, as it was absolutely rightly mentioned, European Union is Africa's main trade partner, but it also invests a lot in terms of peace and security, development, humanitarian aid, migration, good governance. So that's why this, let's say, I just wanted to also put these considerations on the table. Thank you.
Just to follow up, what is the perspective of your African partners? Why are they drafting the data protection laws? What is their motivation behind? Is it only economy, or as I assume, there might be also other aspects?
I think there are a combination of, let's say, incentives and reasons. Sometimes, like, human-centric approach could lead, in some cases, more economic and especially digitalization could be the leading point, but it's not only one reason. We have seen also scandal-generated, let's say, laws when something happens related to surveillance or anything, and then, let's say, states are trying to offer, let's say, new package, new reform to reassure people that these problems will be solved and never repeated. Indeed, there are a number of factors: trade, access to markets, internally building trust of citizens and customers, because with the digitalization, you want people to trust and use those services. Otherwise, this is just investment so you are making in public services or private services. And then to build the trust, you need to reassure people that their data is protected. Although still, I would say that awareness needs to be improved, but people feel and they have witnessed in many occasions, let's say, huge implementation gap, what is in the law and what is in practice, or what is even not in the law, but they have heard that in some jurisdictions there are some safeguards and guarantees, so they want to benefit from the same, let's say, rights and benefits. And obviously then, let's say, this trust also helps to get competitive advantage, get more investments, be more innovative and competitive in those markets. And in terms of digitalization, creating jobs, for example, if you look in Nigeria, there is only regulation, the bill is there, but more than 9,000 jobs have been already created, and there are projections that many more would be created with data protection compliance organizations or DPOs. So there are a number of, let's say, dimensions. An economic dimension, a societal dimension is also very, very important indeed, I would say.
Moritz, maybe you want to come in here?
Yeah, of course, and I like to take up this notion of trust and what does actually create trust. We all know that pretty close to everyone do not really read privacy notices or rarely read privacy notices, well drafted and drafted in a similar way worldwide. And we know that other behavioral economical factors come in, that data protection law is actually not working in the way it was originally intended, that someone is really considering a specific decision and then giving his or her consent, but in many cases, especially with regard to cookies, it's rather a click and forget or a click fatigue we experience. And there are now two ways in analyzing this situation. We could say it doesn't matter, as the existence of the notice gives some trust to the specific individual, or the obligation of the respective undertaking drafting this notice already is a process in raising awareness for data protection. However, from the others, taking sort of the original standpoint of data protection, that we like to have an informed decision of the individual, we have to realize that it's dysfunctional, that the original data protection framework, and we have heard how old it is, and some would also say outdated it is, as data flows have become the new normal. We all share to one or the other extent data, maybe non-personal or personal data, on a basically second by second basis. The old idea of someone just giving a data protection consent in a specific scenario, in a specific setting, maybe at a public authority, is rather not the way how it is perceived today. So all these, most of the laws nowadays, especially those on the basis of the Data Protection Directive and the GDPR, do not really mirror these actual effects and these actual settings, and with that respect, obviously they, and that has been mentioned before, are heavily criticized. Another approach, but it's, as we have seen, not the approach many parts of the world are following, are countries, for example, within the US or within the US, especially California, where we introduce other mechanisms which are maybe even more helpful, something like "do not sell my data" buttons and other specific targeted at specific scenarios where people then really take a decision which is at least a little bit more thought through than just clicking to something which I've never read. And it's also connected to the question that until now at least we still adhere, at least with the classical application of data protection law, that we have to consent in every scenario again and again and again, so that privacy information management system, so-called PIMs, have not really gained speed so far, and that also hinders, and that's sort of the last aspect, also hinders the elephant in the room, which is, to what extent can I monetize my own data, and is it in the end not also a form of freedom that I monetize my data if I would like to do so on an informed basis, and maybe even with the help of a specific partner that could be a data intermediary or data trust, or even a personal information management system. As this last aspect is for me the most striking one, as now the entire world is following the GDPR approach. Europe itself has now a data strategy where we have a multidimensional approach to data, and it's far more than in earlier years that we focus on data use and data usability with regard to the societal benefits, to the individual benefits, to the commonwealth that is associated with that, and the new European regulation goes rather, from the outset at least, a different way than data protection law did in the very beginning, and to harmonize both fields is the great challenge.
As you mentioned, the EU data strategy, for me it was astonishing that it's actually more a political document, and it has a strong political dimension, and also data has more dimensions I mean, it has the human rights dimension, has the economic dimension, has the political dimension, the security dimension. Maybe let's talk more about the political dimension. A couple of months ago, you used the term Datenrealpolitik. I don't know if you actually invented it, but can you explain what you mean by it?
To just as I've tried to explain a couple of minutes ago, one aspect sort of taking reality, taking behavioral economics, and taking the entire setting into account. And as you have mentioned, it's too narrow to look at data protection law just from the perspective of the individual person, as it has always been. We've always had the challenge to balance it with other societal interests. And to be realistic in that sense is to communicate openly and also to underline that there are diverging goals. Data security, data protection, data use, data trade is not, you cannot fulfill all these goals to 100% without touching the other aspect. And if we realize, and you have also pointed to that the individual giving his or her consent that his or her data is used is nowadays not only a decision with regard to my right to informational self-determination, but it's an economic factor, as you said. The question where it is saved and stored, where are the servers, where all the data is located, is an industrial policy question, and has also a security dimension, as you've said. Who can access that data, where and to what extent do we allow access, for example, for other state actors? So to frame it in a different way, the individual is nowadays a little but significant economic actor, security actor, industrial policy actor, and we have to communicate that this goes along with trade-offs we either have to accept or not. We, for example, which kind of countries do we trust that we allow that our data is transferred to those countries? At this moment in time, the EU, simply speaking, decides which countries it perceives as adequate, and Patricia has also mentioned that briefly. So it's a one-way decision by the Commission whether another country outside the European Union has an adequate level of protection or a similar level of protection, and as we have seen, not many countries have gained this status so far. Even countries we might want for different reasons, for human rights aspects, for development aspects, for economic aspects, but also obviously nowadays for security and other aspects. We would like to cooperate and also have common data spaces. We would have to take all these things into account and determine how to trust, and then a one-way decision by the Commission about another country is maybe not the way to proceed. And obviously it's not a way which has opened many data spaces to many parts of the world so far, at least.
How's the perception of the one-way decision by the European Commission in your African partner countries?
Now I was thinking, Professor Greenleaf, in his research, he describes the first generation laws, which are like convention and OECD standards, and the second and third generation post-GDPR. And actually many post-GDPR, the third generation laws now also have extraterritorial scope, which I think is a game changer, because it will lead to mutual recognition. So I think that, yes, indeed, no African state right now has the adequate decision from European Commission, but they are also defining their own criteria. Like, some African countries have even data localization rules, which are also important to consider. Therefore, I think that this developments, and now 36 countries with data protection laws in continent, like majority now with data protection laws, and we see that number of them have already built. So your research also compares, let's say, there were 17, right, countries in 2018 or 16 when the GDPR was adopted or enacted, I don't recall it, but now we have 36, right? So in 5 years, it's doubled, the figure doubled. So I expect that this situation may change, and then there will be a need for even speeding up the process of decision making, and then legal convergence and convergence with between legal regimes really I believe will really support. But then important, obviously adequacy decision is not like comparing the only like laws, right? Enforcement, implementation, other dimensions like political stability, human rights protection, and many other, let's say, important considerations are with this decision. So I believe that there are a number of countries in Africa that will be competing. Who will be which country will be the first recognized by the Commission? And then I also believe that there will be also developing so-called whitelists. Some have already developed, some are planning, and not only the whitelist, but different, let's say, data sharing exchange frameworks, like standard contractual clauses and many others will follow. And I, as an expert, I have already seen the signs of moving to that direction.
So what is needed for African countries to get this adequacy decision actually, and should the EU give it like more early than later?
It depends on the process and readiness. As I mentioned, enforcement is really important, because having the good law is very important but not sufficient, right? Those rights should be, people should be able to exercise, then there should be safeguards. And the major problem that I see in many African countries, but not only in Africa, in Central Asia, in my region, and many others, are the sanctions, which are not effective, dissuasive, and adequate, proportionate. And in main legislations, this is the huge, really obstacle and implementation gap, I would say. So revision of the mechanisms and making those enforcement, let's say, mechanisms more efficient, empowering data protection authorities with those functions to impose sanctions on both public and private authorities. Some laws apply only to private sector. With public sector, there are some exceptions. I think this is also important to take into account. So I believe that then with more enforcement, implementation, and as well as awareness raising and guiding sectors for compliance, because obviously when there is a new legislation, you need to invest a lot of resources to raise awareness. You cannot just knock on the door and say that you are fine because you are not registered if the information about registration was not available and was not pre-planned and let's say communicated. So there are a number of challenges, but many of them are dealing really well, and I think it creates also a very solid ground for Pan-African experience sharing. And I see also this interest. It's much easier to learn from best practices as well as lessons learned from neighboring countries who share the similar, let's say, challenges, some cultural, economic. There are some cultural, economic similarities. So I think that this is also something that I have observed, and I believe that this Pan-African experience sharing and bilateral experience sharing between countries will be increasing.
Is it like sharing best practices? Is that something private sector or law firms would do as well, or is it?
I mean, basically do it all the time in day-to-day work, right? Sharing best practices, and also to some extent, best practices are like the word already says, or the term already says, they're established in practice, right? Because many companies, they realize, okay, if we do something a certain way, then we can copy paste that to another region, and then somehow best practices sort of evolve, and this is why we call them best practices, of course. and maybe one more point, because we talked just about the different laws and adequacy decisions. My impression also is, because recently we see a lot of things going on in the privacy field, a lot of countries updating or at least working on updates of the privacy laws, also, for example, India, I think Vietnam also. And my impression is that in many regards they're moving a little bit closer to the EU because they want to have an adequacy decision. And I think the reason for this is currently it's virtually impossible to lawfully carry out transfers to third countries if there's no adequacy decision, taking into account relevant case law of the Court of Justice of the European Union, also as it is applied by the European data protection authorities. So taking into account the relevance of data transfers, not only for companies, like you mentioned, it's also relevant for other transfers. Having an adequacy decision for the own country is a huge benefit. And as long as there's no adequacy decision, this triggers a lot of issues in practice. You already mentioned standard contractual clauses. Sounds easy, just sign a contract based on a template issued by the EU Commission. That's the theory. If you just have one set of transfers, that's easily done between one entity A in, I don't know, Italy and entity B in Tunisia. But practice is different. So we have a lot of clients that deal on all continents. They have, I don't know, 300, 500 establishments in 80 countries. It's already a challenge to implement a contract that covers all the data transfers between all of these entities just from an EU perspective. And if there's no adequacy decision, you need, because many countries also have similar requirements to international data transfers, not all countries, but many. If you want to cover all of these requirements, you need to put all of this into one contract. And this is a huge, huge challenge. So we've done that for many clients that need, I don't know, a contract for, like I said, 300 entities, 50 countries. So you start from EU, then they're already overwhelmed, and in many cases don't even get to other regions because it's way too complicated. So having an adequacy decision in place, or having a region where you can, at least in theory, transfer data freely, I mean, the legal basis needs to be there. This is a huge, huge help, because otherwise even complying with this relatively basic requirement of having a contract in place is a huge challenge.
So adequacy decisions are needed, but they also...
I think what you are telling us, and it's totally understandable from a practical viewpoint and what is necessary from a practical viewpoint, it also shows where the true problem actually is.
Absolutely.
That we have a system where every country has its own data protection law with an extraterritorial application in many cases, and with a system of adequacy decision or other systems steering or allowing data transfer between different actors. Far too complicated, especially for small and medium-sized enterprises, which are sort of, it goes to the heart of the economic problems associated to too complicated regulation, even a problem in Europe, but also a problem obviously elsewhere, where a situation where we do not define areas where data free flow with trust is possible, hinders us, or does not hinder us, but increases the compliance costs and the legal compliance costs necessary to do that legally in a decent way is for me rather a symbol that the system is worth revising.
Yeah, I totally agree, especially in particular as you raised, or as you mentioned, the term trust, because trust is so important in this field. And maybe so to some extent, the strict requirements, at least as they're interpreted by the data protection authorities and sometimes enforced, somehow undermines the trust, even though the intention is the complete opposite. They want to they want to do a good thing, but in the end it's so complicated that data subjects lose trust because they believe companies cannot even achieve compliance. And in some regard it's true, sometimes also because especially authorities like a little bit overshoot here the aim when they demand more than is practically feasible and also understandable for the data subject. We've talked about privacy notice a couple of times. I mean, who reads the privacy notice? I mean, I do it. But who,
Everyone who is paid for it.
yeah, but I mean, that's right. But that's like you said, it's not the purpose, right? It's about the data subject building trust, giving an explanation why data is processed. Maybe there's even a consent afterwards. But in practice, if we draft a privacy notice, we're doing it for the Data Protection Authority. And one person who we both know, she once told me, if the Data Protection Authority wants us to draw pink rabbits in the privacy notice, we do it just because they want it. It doesn't hurt us, by the way, but we do it. And I mean, this cannot be right.
I think this also gives me an opportunity to just add one point regarding enforcement and the authorities. What is lacking in many countries so far, and maybe I'm wrong, but we haven't spotted it in the North African context at least, is that private enforcement is not very is not often seen at least. And we are seeing nowadays in Europe that private enforcement, that is to say that someone is claiming damages for data protection violation, is actually a mechanism that can be very effective, especially if you have systems of class actions or other mechanisms where consumer protection agencies or others are able to bundle these types of claims. And that might even be a perspective in countries where for different reasons maybe the public enforcement is not that strong. So that's something also for the future that needs boost, and privacy information management system and other tools, if implemented correctly and are operable, are obviously also a mechanism to boost that kind of situation. So basically to automize scenarios where you have violations and to automize also the damages, even if it's a small sum to be given to the individual. The other point I just like to add is that as we have seen that this process of harmonized rules has led us to a scenario which probably must be called a huge path dependency from where we have come and how the rules are now framed and how everyone is now sticking and aligning to these rules. So at least from an academic perspective, where you might sit back and say, oh, it would be interesting to see what are the different offers on the legal market or on the legislative market to see. Yep. We're rather foreclosing the market of innovative regulatory ideas. At least if some, for example, just taking for a moment the scenario that the EU would like to implement an US-style approach to data protection, and you could argue that even in the US we have a couple of rules in specific sectors, and we also have enforcement mechanisms which do work with regard to the Federal Trade Commission, again, so on and so on. We wouldn't be allowed to do that if we've risen the standards everywhere else, and everyone else would then say, oh, we are not adequate anymore. So there is a huge trade-off in raising the standards maybe too high or to implementing it in a too sort of a concrete-like way, maybe.
Yeah. Mm-hmm. Before I ask you what to do about it, I would warn the audience here. We have the possibility you have the possibility to ask questions, and you could already take the time to prepare some. But before, I would like to know from you what you said. We are on this path, and we can't change it anymore, or we need a mutual understanding and recognition. How can we reach that? What?
Actually, I have witnessed and participated in many projects, activities leading to that, and especially in Africa, and this is very nice to see, like different European Union institutions, member states with their implementing agencies are working together to taking into account the local needs, context, to deliver the knowledge, experience, and define together with the national counterparts and authorities the priorities for the future. And this helps to bring resources, expertise, and achieve results, meaningful results, mutual benefits in more effectively and efficiently. International cooperation also for data protection authorities is becoming very important, especially when it comes to the enforcement of cross-border nature of cases. Experience sharing is also very important. And what you were just said regarding the enforcement, let's say, related challenges, one of the aspects contributing to that could be, there are many, but the second generation, let's say, post-directive, let's say, laws, they contain a lot of information about composition of authorities, but sometimes the independence with number of dimensions. Independence should not be on the paper only, but operational independence, functional independence, financial independence. It matters a lot. To be effective, you need to have concrete powers, and in many jurisdictions there are so many procedural barriers for data protection authorities to be effective. They need to go to court, they get some warrant before they do any operations, and everything could be challenged because it is tied with the national, let's say, legal system. So convergence in terms of the independence and powers of the authorities, obviously the composition, it's up to the country to decide whether it's a single commissioner or the commission, whether this is authority with single mandate to oversee only data protection, or this is a, let's say, authority dealing with number of other, let's say, competencies. But the key components of the independence, I think, is very important to promote more. And this is also opportunity for the EU member states and developing partners supporting African and other regions in developing their data protection laws.
Tobias, from the law firm side, trade side, what can trade organizations, or I don't know, lawyers organizations, what would you do, or what would you prefer for international approaches or fora to get a better system or mutual understanding?
I think there's not just like one approach, but in particular on the level of the data protection authorities cooperation, I think it's very important, as we just heard, because in particular the European data protection authorities, they already closely cooperate. They need to. They're forced to by GDPR. They publish a lot of guidance, which is really helpful. So I don't want to do all the authority bashing. So it's really helpful. This is what we work with in practice. This is what our clients work with. And I think based on this, other countries can learn a lot. Which doesn't mean they need to do it the same way, because they could also come to the conclusion maybe we need to do it differently because the experience in Europe is maybe not the best. We already talked about privacy notices, consent, and there's in this regard, I think there's a lot to learn. So cooperation is key. Yeah. But maybe not only from the authorities alone, so other stakeholders need to be involved, obviously. Because this is what I miss sometimes, like this practical perspective, and not just from the industry or companies, but also from data subjects. My impression is that like the voice of the data subjects, the ones that should be protected, is not heard at all. How are data subjects involved in data protection policy making? I mean, they vote the parties, but that's it. they're not really involved. So it's basically done on a very high political level only. So maybe this is one aspect that should be considered more. What do the people want?
Yeah, good aspect.
Actually, the baseline studies, I, as a consultant, suggested to conduct baseline studies before like enacting or implementing the legislation, really to understand even how industry is prepared or aware about the new obligations, like what are expectations from the side of citizens, even which channels they prefer for communication, because sometimes the communication and awareness raising, it's very costly, and you may invest in channels which are not reaching people in a way as you wish. So they, let's say, establishing doing some fact-finding, let's say, mission, understanding the industry perspective, public sector perspective, as well as readiness for the implementation, like even what type of guidance they will need. Sometimes, I also work with authorities to provide more practical, let's say, guidance. Sometimes like self-assessment tools are very convenient, because especially for small and medium-sized businesses, because they cannot afford like engaging law firms, and sometimes they need like tools that they can use to self-diagnose and then define. And by the way, some authorities in Europe as well as in other regions are developing very innovative and efficient tools, self-diagnosis type of tools that help small, medium-sized and big businesses to identify challenges that they have, and then even provide easy solutions. And I agree that practical, very practical and pragmatic guidance is very important indeed, as well as engaging data subjects, because we're developing that all to make sure that they're in control of their own data. So how we reach out and how we listen to their needs.
If data authorities cooperate, is that enough?
Probably not, as we have seen that data is a very unique good. It might have the same value as gold. It is at least not oil or gold in that sense that only one person can use it or only one person can have it even. But data is in the end codified information, or information that is automatically processable. And this leads us to the difficult scenario that obviously data is of value for different actors in different settings. And that is to say that only a data protection authority perspective is already today not enough, as we can see from competition law authorities dealing with questions of data protection violations. We also have the consumer protection dimension. We even have in different countries worldwide, including in African countries, where there is a strong consumer protection and competition authorities, sometimes also dealing with questions regarding data protection. So it's also a question of how the institutional design is actually made. And as we have seen, sort of an approach which mirrors that we have to balance at the same time individual interest, economic aspects, a balance between innovation and risks in the very end, and a balance between an adequate level of cooperation and data sharing and data access for specific actors, and you might say competition where everyone is just is in full control, to use that classical framework, and only taking all these different layers together will lead us there. And to say it only briefly, the new thinking of the European data strategy, thinking in data spaces as being ecosystems where data is flowing in a specific sector or with regard to a specific set of data, mirroring the different actors, be it private, state actors, commercial, non-commercial actors, researchers, is the right approach, as the same information can be used by different, and the regulatory task is to calibrate the specific interest in these data spaces, which is to say that openly, not only the dimension of the individual, that's just one of the different dimensions. This has been a little bit hidden, but has been always an aspect that we have seen in data protection law, but it's becoming more prominent nowadays. For example, when talking about the European health data space or other data spaces, where we just have to calibrate the different interests.
I would love to dig in deeper here. However, I would love to give you the chance also to ask questions. Do we have already questions? If so, we can collect one or two.
So first of all, thank you so much. Every time I find it extremely interesting, because it shows us how manifold the topics are that deal with data protection. I'd like to ask you about two of them, and Tamar, you especially, working in Africa. The private enforcement was mentioned by you, Moritz, but in terms of kind of state enforcement, in your experience, how big is the political will to actually see it through? Would be something I would find very interesting. And my second question to all three of you, or actually all four of you, because I'd also be interested, in hearing what GIZ, in your experience, does in its work on this. We often speak about kind of international competition of political systems, especially if we look at China. Now, you've mentioned several times that the GDPR sort of is the template for a lot of these regulations in Africa. But in your experience, does China also try and export kind of their way of dealing with data protection or data regulation? And the same question also in regards to the United States. How involved is the United States in exporting kind of their sense of data regulation? These would be my two questions for now, but I would have more.
Good. Who wants to start?
Yes, the public, let's say, enforcement in public sector is indeed a challenge due to the number of factors. Political will could be one significant one, but in many legislations there are no mechanism to impose administrative fine, for example, but still if the law provides for criminal, let's say, liability for an offense, then it's possible, although I have not seen yet this practice, but there are a number of factors. But at the same time, for the public sector, the similar may happen in other jurisdictions in Europe, where in the public sector, let's say, the implementation and enforcement could be in a different, let's say, format, but still then other powers. It's not only like administrative fine is not something that brings the justice, right? You need to bring remedy, you need to prevent future breaches, and still data protection authorities have strong instruments to guide, let's say, data controllers from both sectors, what to change, what to improve, what security measures, what technical measures to implement. And in that terms, I see a very good cooperation between authorities and public sector, and they're also have consultations, they're engaged into dialogue, and even some data protection authorities start with developing guidelines targeted to public sector, because in many states there is an understanding that if the country is introducing the new data protection law, then the public sector should be the one who will show, let's say, how this could be implemented in most effective and efficient way.
Thank you very much for the questions especially regarding China and the US, which gives me the sort of the chance to highlight one significant point. To look at China is very interesting with regard to data protection law, as the data protection law itself, the personal information protection law, there's a new one. I think of 2021, but there have been other laws before. If you look at it in many parts, it's very similar to the Data Protection Directive or the GDPR. So from the outset, you might see now even the Brussels effect is working there. However, and that's at least true to some extent, that obviously also there is a notion, obviously, that individuals should be protected, especially with regard to companies, but also even with regard to state institutions. It's at least something which is set in the black letter law. However, obviously, with some two big exceptions. The first one being more from a significant one, that is potential backdoors for security agencies, or general potential backdoors with regard to the state, that obviously is different and gives it another direction. And the second one is also significant, and that's the question of data transfer or non-transfers, which leaves us to the question of data localization, for which China is also known, and Russia is another example where we have seen rather strong data localization rules. Which is to say that it's not easy to transfer data to other parts of the world, or transfer is dependent on a authorization process. This process of data localization is often framed in a way that one is saying that's a rather protectionist approach, that data should stay within the country. And that's true from the outset, but the reason why, obviously, is not so easy to identify. It might be that I would really like to have state access or security agency access to that kind of data. It might be that I have taken the decision that the data of my individuals in the country are only protected if they are not transferred. Or it's part of an industry policy approach that I like to have the data stored in my own country, having the servers in my own countries, have businesses in my own country. And that links to your question, what's the influence on the African continent? I think independent of China, different countries have thought about data localization for different reasons, but also from an industry policy reason, which is understandable. And you could even say that obviously the European system is also at least a soft data localization we have, as we also obviously do not allow the transfer without any further requirement, but have implemented a sophisticated system for data transfers where adequacy decisions are the most prominent example. But that obviously also goes along with that notion that we generally think that data is first of all processed within the own territory.
Yeah, actually, the last point that you mentioned is very important. So it's not just the rules around data transfers that sort of lead to a factual data localization, but the data protection rules in general, including the requirements to have a legal basis. So if you already need, for example, consent to enable the processing in general, and if consent is not obtained, the data stays where it is, or it cannot even be processed, right? So the overall legal framework already has effect on how the data can flow. So I think this is very important to note here.
But at the same time, we should not, let's say, overestimate in terms of adequacy decision, because it's also very important to understand that there are other mechanisms as well, sure, provided by GDPR, as well as they share the same type of principles, and channels are shared also by many African let's say, laws. And I think this is important research question to be explored, like what are the differences, similarities, and from practical point of view, what would be like what could be the next steps. At the same time, like what is important, and I think this is there is an understanding that like adequacy decisions and other let's say data transfer mechanisms allow you to, let's say, export data from EU and process there, create jobs, new businesses, new opportunities, right? So there is advantage to be compliant, to be convergent, but many other frameworks are not offering the same opportunity. They're more about, let's say, exporting data from Africa or from other jurisdictions without sharing or giving, let's say, offering the similar opportunities. I think this is also very important point to build understanding, like what are the benefits and what are the, to compare different, let's say, existing frameworks for data transfers.
Very good. We still have time for one or two questions.
Or maybe you just want to share your own opinion about the discussion.
So one more point I'd really be curious to hear your opinion on is, so you mentioned raising awareness several times. And in regards to raising awareness with us data subjects, right? So I usually live in Beirut. Now I'm in Berlin. Everyone's asking me that I meet, what are you doing in Berlin? And I tell them, so we have an event on data protection law in Northern Africa. We're presenting it here in Berlin. And people always tell me, oh, that's very interesting. And then I tell them a little bit. And then you find, the interest kind of goes away a little bit, because I still find data protection a very niche subject. How, raising awareness with us data subjects, how are we doing here, but also in Africa? And what is the best aspect to move forward with this? Because I sincerely believe it is extremely important, because as you've mentioned, there's so much that can be done with the data, and we're not aware of it because we don't read the privacy notices, because we don't really, read into it. What can we do?
Be very innovative and creative, and don't tie us with the traditional, let's say, channels, traditional methods, and engaging, for example, use, because you have to know your audience, right? You have to know, that's why I talked about the need to conduct some kind of researches and analysis about expectations, about even communication channels. And I actually have seen, even in many African states, how they engage, let's say, celebrities or content creators in spreading those messages. Because we as you have said, long privacy policies or long, let's say, leaflets or brochures shared is not sufficient, it's not enough, it's not effective. That's why I think, and many African authorities are showing really this innovative and creative approach. That's why I'm saying that there is a lot to share and learn.
I think that privacy information management systems are a key factor. If an individual is realizing, and it's sort of, and the law is adapting that is possible, that to use one program where I can actually, I'm only asked once about my preferences, how data can be shared or cannot be shared, and I have then the possibility to participate also in the value that is generated with that kind of data. So in the end, or maybe give some sort of kickback or even some sort of sum I gain from that. I think that would raise a lot of awareness as it could give people more than nowadays. Maybe there's a growing extent, but more than nowadays, an idea of what is the actual value of the specific data they share. That does only function if other actors also are in place, data intermediaries. So that's something like Airbnb for data sets. So as we normally do not know who might be interested in our data, we obviously use platforms in many parts of our society for data sets, may it be personal or non-personal data that is not so developed so far. The new Data Governance Act is trying to push that with new rules on data intermediaries, and it will be very interesting to see whether that gives a push to that development. Because in the end, an ideal situation would be that everyone is just generally setting its preferences. The data is managed by such a program, and I have a fair share of my data being used, and I might even be pointed to the fact that there are different scenarios where I can donate it to data altruistic organizations. That would be a good development.
Yes. And maybe one other simple thing that is needed is just time. I mean, in many regions, privacy laws are just evolving. It's something new also for data subjects. In Germany, it's also in the EU, it's taken a long time till we arrived at the point where we are right now, where, like you said, data subjects enforce their own rights by raising damage claims. Actually, something that we quite see a lot in practice right now. Like 25 years ago, who cared? I mean, of course, there were some kind of claims with regard to marketing emails because it was something obvious, but more it's something that was molesting people. But people weren't really thinking about privacy, data protection. And even when I went to law school in Münster in 26, so yeah, 17 years ago or 16 years ago, and went to the privacy lecture, and people asked me, okay, what kind of subjects do you go to? It was data protection, privacy. What is this, right? No, people didn't even know what data protection was, and that is not that long time ago. And now if I tell people I work in data protection, everybody knows what I'm talking about, right? So in other regions, it may just take a little bit of time till people understand the concept of data protection law, not privacy, because privacy, I think it's a concept that is known across the world, even though there's a lot of cultural differences, how privacy is, this concept is just different, right? And specifically, again, Germany, I think in Germany, but also the US, privacy plays an important role. Nevertheless, the data protection frameworks are very different. But it's taken a long, long time.
Do we got another question? Yes, one. Last one.
Hi, first of all, thank you very much for this very interesting panel. It was super interesting to see how these different lenses on data protection can react from academia to practitioners. But now, the overarching question that stays in my mind is, when we talk about data protection in Northern Africa, we are talking about a region that goes through political instability after political instability. We are talking about economic hardships, we are talking about social hardships. Given the importance of the topics and the effect it has and the importance of data protection on the rule of law itself, how can we today look at the region and convince the region on the importance of these data protection laws and updating these laws to be up to the global standards that we have today?
To whom is this? To the whole panel?
Whoever has the answer.
$1 million question. Indeed, yes. You know, sometimes the regional approach could be the right approach, but sometimes you may need individual approach. And that's why I said that everything needs to, context really matters. And then there are a number of instruments, obviously. EU institutions as well as EU member states have a number of instruments to use for promoting, let's say, human based approach when to promote privacy, even the economic aspects of that, multilateral, bilateral formats. And in many countries I have seen that there are even conditionality in terms of financial support, but with this conditionality there is also, let's say, support in developing legal, institutional, regulatory framework. So sometimes, at the same time, yes, at the regional level, competition, healthy competition is something also to be considered and used. Sometimes it's very efficient to see that neighboring country is developing, progressing. And then what I would also suggest is that the dimensions that we have spoken about, I think they need more facts and figures. For example, if you will demonstrate what economic impact, what societal impact, what individual, at the individual level, on the state level, including in criminal justice and many other fields, which really matter, health system, education system, if we will be able to demonstrate those success, let's say, cases, I think that it will definitely increase the motivation to be a member of the club and take seats in those discussions, cooperation platforms, and many other areas. So, yeah, this will be my feedback.
I think it is, adding to that, important to communicate that data and data use, and that is also to say data regulation, framing that use, is important for the individual level, for the collective level, for the company level, and also for the state level. It defines how information is used between various actors within a society and within a state, and it's ultimately linked to the competitiveness of that society, how it is protecting individuals, but at the same time, what's the take on innovation policy, and what's the take also on uses for other social goods or for other Commonwealth issues. Health data and the health system is probably the most prominent example, but that's also true for non-personal data if we look at climate change data or agricultural data. And taking that all together, it should be of interest to everyone how this value is distributed within a society and how it is possible that everyone, the individual, but also companies, but also the common good, get its fair share in that information that is nowadays very easy to collect and also easy to analyze. So that's the positive. I think the positive approach, that it's not about hindering data processing, but it's about calibrating useful data processing so that all different actors benefit, and benefit also to that extent that it opens up the possibility to have data spaces, data rooms with other parts of the world. It influences the possibilities for research, it influences the possibility for trade, for e-commerce, and obviously also for cooperation with other states with regard to security aspects. And that is, from my point of view at least, the way we should frame it.
You want to chip in, or you're good? No.
I'm not sure. Do we still have a little bit of time?
I grant the chance.
Okay, thank you. So maybe one more thing that I was thinking about is, because we already talked about that before, I talked about that before, the trust, education, awareness on the side of the data subjects. And this is basically also the core of data protection law and part of its history, right? Data protection law basically developed based on protection of the individual not against, but with regard to the processing by the state, not by private companies. So the first data protection law of the world, it just covered the public sector, right? And maybe this is also a good starting point, because this is something people better understand. Things like behavioral advertising, I mean, people see the outcome. You mentioned it before, the ads that you saw on cat food. This is something, they see the outcome, but people don't understand it. But if they go to an authority, they know their data is collected, maybe by the police, something happens with the data. Maybe at some point you're confronted with some of your data, things that you maybe did in the past, bad or good, whatever. This is things that people understand. And in particular, in this relationship between state and the individual, data protection law can be the basis for trust. And this is maybe the starting point where to implement data protection laws, because this also shows to some extent, which level of, I don't know how to say it, it's a certain level of I don't know how to explain it. Maybe we just leave it here.
We leave it here. It's a clear sign that we have to conclude here. It's a bit hot also on the stage, and it's a good point to end this panel discussion. I want to thank you again for being here with me today, especially, of course, thanks to Patricia for the study. And the panelists for being here with me on stage, and also a big thanks to the organizer of the Konrad Adenauer Foundation. It's clear that this discussion won't end here, but I think you might stay a bit longer, and we can continue the discussion off stage and maybe on the next panel discussion after the next study. Thank you.
Thank you.
Thank you.
Das letzte Grafik habe ich. Ich dachte, du hast schon.